Can you protect a business process by way of intellectual property? Generally, the short answer is no. What do I mean by business process? I mean a process or a method by which you run your business. So these would be processes that you've got in your procedures manual. It might be a process of how do you get a client from downloading your free offering and then getting them into your sales funnel, and then who rings them, what your next offering is, that kind of a process. That process is not something that can be registered by way of intellectual property. Now, there are other types of processes that can be. These are called methods of manufacture, and one example would be extracting gold from rubble. If you had a new way of extracting the gold from the rubble, that process, that might be patentable if it meets the patenting criteria. So that kind of a process, that method, it's called a method of manufacture, that is patentable, but not just general process, just general how do you run your business, how do you market your business. Those are not registrable by patent. You can sometimes get protection for a process by using a trademark. And for example, my client Elizabeth Campbell, she is the word stylist, and Liz teaches people about blogging and writing and that kind of thing. And Liz has a special hourglass that she has created. It's she can draw it, the hourglass, with each stage of the process of, it's actually the format of a blog, and she has been able to get protection for that because you can reduce it to a physical format, the graphic format, the image, and so the image is what we have got protected for her as a trademark. Your processes might have some protection by way of copyright, and what I mean by that is when you create your process manual, your flowcharts that you use internally within your business, first, don't copy from anybody else because you might be infringing somebody else's copyright. But when you create your own, copyright automatically comes into existence when you create the written format of those processes, and you own copyright in that written format. So you can stop people from taking the written format and copying it, publishing it, putting it on the internet. And so that comes to you for free from copyright. It automatically exists when you create the process. But you cannot stop somebody from taking that process and actually following the process. So you can only stop them from copying the written document, you can stop them from publishing the written document, but you can't take them from taking the written document and then doing what the process says. So one of the best ways of dealing with protecting a business process that you want to keep to yourself, you don't want other people to monopolize, is by way of a confidentiality or non-disclosure agreement. A few years ago, I had a client who approached a large government department, and he had an amazing process that he wanted to talk to the government department about. It was going to be a process for managing employees, and he had come up with it. It was very different to anything anybody was doing at the time, and he did a presentation to them of the process that he had developed, and they were very interested. And his point of showing them the process was that he was hopeful that they were going to pay him to come in and implement this process in the government department. He did not have any contract with them, he did not have any non-disclosure agreement or NDA with them, so he went and he did his presentation, and then about 6 months later he was talking to somebody from the government department, and he said, well, are you going to get me to come and implement the process? And they said, well, we don't need to, we've already done it. And he said, well, how did you do that? It was my process. And again, he didn't understand that you can't have ownership of a process. You can't prevent somebody else implementing the process that you've explained to them unless you've done it on the basis that they're not going to do that. So if he had had a contract with them, a confidentiality agreement or a non-disclosure agreement or a non-use agreement that said that the only reason I am giving you this information, the only reason I'm explaining my process to you is so that you can decide whether or not to hire me, and if you decide not to hire me, then you agree not to use my process. If he'd had that document in place, then his process would have been safe. But unfortunately for him, he did not have that document in place, and there is no law or reason for the government department in that situation not to take that process as their own and implement it and basically cut him out of the loop. And it works the same way. If you're explaining your process to your clients or your potential clients, there's nothing stopping them from going away and using that, whatever it is, marketing process within their own business, unless you've said, look, we're having a preliminary discussion. The point of the discussion is that if you are happy with what I tell you, then you will get me to come and implement this in your business and you'll pay me to do it. In that case, if you've got that agreement in writing, then you're fine, your process is protected. So obviously, very importantly, if you're going for one of these NDAs, non-disclosure agreements, make sure, because assuming that you want to keep your business process confidential, make sure that you get them to put it in writing. If they just agree verbally, later on there might be an argument as to whether or not they actually did agree. So if you get it in writing, then that just makes sure that later on they can't argue and say they didn't do it. Even if you do it by email, anything like that, make sure that it's valid. The other point with a non-disclosure agreement or a confidentiality agreement is if you get them to sign it after you've revealed the information to them, then the agreement is invalid. So if you want them to keep the information confidential, you have to get them to sign the agreement before you reveal the information to them. Otherwise, the reasoning behind the law is once you've told them, it's no longer confidential. And it's then too late to get them to agree to keep it confidential. So business processes are really tricky to keep a hold of and not let other people use your processes that you develop. And the only other way really of keeping control of your business processes and making sure nobody else uses them is to keep them as confidential information in-house within your business, where it's like Coca-Cola, where they used to keep their recipe secret. You keep it secret and nobody else has access to that process other than a few key people, and again they have to sign confidentiality agreements before they become exposed to the process, so that you know that it's not going to get out and people aren't going to become aware of your business methods. My name is Catherine Warburton. My clients call me the Legal Lioness. Do be in touch if you need any help with NDAs or confidentiality agreements.